Everyone, I'm Helen Postel Hudson with AMCS. Welcome to our Board of Directors training this morning. With me on the panel is Amanda Heaton from AMCS to handle anything that we have that may need technical advice. And our speaker, Paul Rahn. Paul is an HOA collections attorney. Firm is Robertson, Hollingsworth, Manos, and Rahn. And Paul, without further ado, I'm going to turn it over to you.
Okay. Thank you, Helen. So the funny thing about being introduced as an HOA collection attorney is it's not necessarily the thing that you want to lead off with at parties. But that being said, just a little bit about my background. I've been practicing in this area of the law for the last 24 years. Our firm also specializes in construction-related litigation and other construction matters. And the homeowners association portion of our practice works in with that because there are some similarities, and some of those similarities are some of the things we're going to discuss today. So today's discussion and training is really to introduce you to the collections process for homeowners associations, the ins and outs and sort of the why and how. And then I'm going to give you some maybe framework and how things can improve with your association's collections process, and how that works in with just overall running your association. So first and foremost, the place that we start, and the questions that you get all the time when you're on the board or when you have an owner who's upset about this, that, or the other thing is, why do I have to pay assessments at all? What is it that is out there legally that requires me to pay these assessments? And that also goes hand in hand with the question as to what are these assessments for? And we're going to talk today about two different structures. Condominiums are governed by the South Carolina Horizontal Property Regime Act. And whenever you hear the words horizontal property regime, that's literally just condominium. So just interchange those in your mind. And those rules and regulations are codified under that act. And so they're a little more rigid and strict in how they operate. But those are the basis for how the legal basis for how and why, if you own a condominium and you're in a condominium association, you are required by statute and by law to share in the common expenses of the association. And those common expenses include a lot of times the upkeep of the buildings of the condominium and of the grounds, as well as the administration of the building and the repairs of the common elements, the maintenance. And also with the Horizontal Property Regime Act, there's a formula used to calculate how much you have to pay, and it's based on how much you own. So what percentage of ownership of the entire condominium building does your unit take up? And that prorates to the unit owners and their liability for expenses. The Horizontal Property Regime Act also specifically states that no co-owner, which is just a unit owner, may exempt himself from contributing towards such expenses by waiver of the use or enjoyment of common elements, or by abandonment of the apartment belonging to him. In other words, if you live in a condo, and this part is also applicable to any neighborhood homeowner association with houses, townhomes, or condominiums, but you can't say, I'm not going to pay my assessments or association dues because I'm not going to use the pool, or because I don't use the grounds, or maybe I don't want to use the workout room or something like that, so I shouldn't have to pay. Well, the Horizontal Property Regime Act says we don't care about that. And in fact, if you vacate your unit and just abandon it, you're still going to owe these assessments. And that's something that's specifically laid out in the master deed and in the Horizontal Property Regime Act. And this is a common type of provision, and it's common to other condominium acts in other states. And one of the things that we can talk about with respect to condominiums, and we're not going to focus all on condominiums today, we're going to talk about both, but this is a sort of an interesting issue, which is under the Condominium Act and under that passage I just read to you, there's no such thing as a self-help remedy for a unit owner. And what that means is not only do you not get to say, I'm not going to contribute towards assessments because I am not using the pool, you also can't say, I'm not going to contribute assessments because the board hasn't fixed the leaky roof, or because I don't like how the board is running the parking situation and the parking rules. So it's literally codified by law that says you're going to pay these assessments, and it's irrespective of what anything else going on. You pay the assessments for the common expenses of the association. So that's how we get there with condominiums. However, with homeowners associations, you have something similar but not the same. And what that means is you don't have a specific statutory scheme for the collection of assessments. What you do have is law that says, even without having that specific statute, like the Horizontal Property Regime Act, in South Carolina, a covenant to pay assessments runs with the land and binds the owners, even if not explicitly stated in subsequent deeds. Okay, so what does that all mean? Whenever a neighborhood gets created, there's a set of covenants and restrictions that are recorded in the Register of Deeds office. And those are what the developer, who's also known as the declarant, those are the framework of the association and the rules and the matter and how things are going to be run. And it's like almost setting up a little government, a mini government. So what the law in South Carolina on that is they give pretty broad discretion to the developers who create these covenants and restrictions as to what they're going to put in them. And they all differ by neighborhood, and they definitely differ over time. So, and we've had experience with master deeds and covenants and restrictions that are 40 and 50 years old or older. And then we have some that are, just recorded recently, and they all vary into what they're focusing on and how they're operating. But overall, each one is going to say something along the lines of that the association is created and each unit owner owes an obligation to pay assessments to maintain the common elements of the neighborhood. And so it may not be the common elements in the sense of a condominium where the building is the common elements and the units are your portion of the insides of the units or your portion of what you own. In this case, the common elements would be something like the pool or the clubhouse, or maybe even the street lights or the landscaping at the front of the neighborhood. Just depends by neighborhood. And that also depends on what those expenses are going to be. But in any event, the law and how South Carolina courts look at it is that the administration of how this gets collected and how it's owed is up to the discretion of the how they set it up. So again, it's a little less rigid in homeowners associations than it is in condo associations. But again, there's still the obligations of the owners to make those payments to pay for what the association incurs in running and taking care of managing the property, repairing the property, and routine maintenance, and whatever else the documents say. But there's, like I said, there's a little more flexibility in terms of what the documents allow and what the discretion of the association might be in dealing with those issues. And so one issue that comes up in terms of condominium collections that isn't present in homeowners collections is that condominiums can be put in a bind or a little bit of a more strict problem if they're trying to resolve a debt with an owner and the owner offers less than the full amount of what's owed. And the reason that's a problem is because if the board of a condominium association takes less money, it increases the common expenses of others. And because the statutes say common expenses are to be attributed pro rata in those percentages we were just talking about, they really aren't able to accept a lesser amount. And so and there's a specific statute that says a unit owner can't be excused from payment of his or her share of common expenses. So you don't have that with typical neighborhoods. What you do have is the discretion to work with the owners on some issues that arise, like some of those debts may be for, if you have a violation fee or something like that, those can be negotiated. And I think that's probably true with condominiums. But with condominiums, there's no room for the association to negotiate on the actual assessments, be it a regular assessment or a special assessment. Those cannot be discounted. It's not a great idea to discount those with homeowners associations because it's the same thing that happens. If somebody pays less, that means everybody else is going to pay more. But there's more discretion for the association in dealing with things like late fees or other charges that might be on the account that can be more easily negotiated, whereas it's a little bit more difficult to do with condominiums. So let's talk about what the collections process is. And this is something that we've refined over the last 20-something years in terms of what we do and how we do it. And we change it, and it sort of comes back and forth over time, just depending on what the conditions are in the economy and in the market, in the real estate market. But the process of collection, let me just walk you through what that is. First of all, we have a monthly delinquency report that we get from the property management company. And that report lists all the unit owners who owe money or the homeowners who owe money. And an attorney or paralegal at my firm will review that report. And we'll go down and look and see, who's on the naughty list, who's, who owes what, how much that is, and what actions have previously been taken in trying to collect that debt. And we try to do this between every 30 and 45 days. We sit down and look at these reports. And once we go through that, we come up with one of three actions that we're going to do. The first thing that we do when someone's behind on their assessments is we'll send a demand letter. And that demand letter is really just a collection letter that you might see from any bill collector, but the difference being it's on a law firm's letterhead. And in my experience, that alone, just a letter from an attorney, can result in collecting money about 90% of the time. And I think Helen might agree with me, but it's typically the easiest thing that we do. It's the cheapest thing that we do. And it's the most effective thing that we do is just send a letter that says, hey, I'm a lawyer. I represent the association. You owe this much money. Here's how much it is. Here's how it breaks down. And you need to pay it or bad things are going to happen. And we don't really threaten. We're not mean. But we say, hey, this is what's going on. And if you don't pay it, we're going to take it to the next step. And like I say, that in and of itself is responsible for the majority of the money that we collect. And so we'll go back in a month or two when we look at our report and that name won't be in the list anymore. And it's really the most, in terms of the reach and the impact and the bang for the buck, that's the first and best thing that we do. Now, That doesn't always work because there's still 10% of the cases that people, there's different kinds of reasons people don't pay their assessments. Sometimes it's a can't pay situation where they have money problems and they just can't afford it. That's a real issue. We saw it in the previous recession, and we may see it again coming up if we really do go into another recession. And I'm going to talk about the ramifications of that a bit more in a minute. But that's the can't pay situations. And then there's the won't pay situations, or people who are just, I'm not going to pay. I'm just not going to pay my assessments. Those ones never end well for the owner. Not that the can't pays end well necessarily, but the won't pays, those are the ones that, for some reason or other, they have misguided advice, or they think this is the least important debt that I owe, and there's not going to be any way that they can make me pay this. Well, we can. And that involves the next step in the process. So the second step of the process is the filing of a lien. And what is a lien in terms of what it is physically and what it does? I'm going to talk about that. But what the filing of a lien in the Register of Deeds office is basically securing your claim on the real property, on this unit owner or homeowner's property. And it functions in a similar manner to, I would call it an involuntary second, or even in some cases, third mortgage, if they have a second mortgage or a home equity line. And what that means is if we file that lien, we're tying up the property, and we're tying it up so that they can't sell it, they can't refinance it, they can't give it away without it being subject to that lien. And so that does a few things. One is it makes the association a secured creditor, and the debt is now secured or physically linked, legally and physically linked to that real property or that unit. So that is something that is a very powerful tool. And even if you just do that, you file a lien, at some point, if you don't do anything else, that person's going to want to sell or refinance or do something with their property at some point in the future. And when they go to do that, the closing attorney is going to run a title search, and they're going to find that mark on the property. And they're going to call us and say, hey, can we get a payoff for this lien? Because we need to know how much it's going to cost to resolve it so we can sell this property or refinance or whatever it is. And we get a lot of calls. We get them daily at our office asking about, hey, so-and-so's got a closing. Can you give us the payoff information? And we do that as a matter of course every day. But it takes it from just being a debt on your books as an association to being a debt that's on the public records of the Register of Deeds. And it means that, as I said, even if you don't do anything, in the short term after you file that lien, you're still going to have a measure of protection that you otherwise wouldn't have. And in the event that the owner files for bankruptcy, which happens from time to time, and it may be a Chapter 13 where they're trying to reorganize and trying to get back on track, or it may be, a Chapter 7 where they're liquidating. But in the event that happens, you're in a better position as a secured creditor, and you'll be treated with priority over all those creditors who don't have secured claims. And that could be anybody from a credit card company to, even a car loan that would be secured. The car might secure the loan, but it doesn't go against the real property. So you've got a literal hold on this property. And as I said, it's an extremely effective way for an association to secure their claim and ultimately collect their money. So that's the second step. And that step usually sparks a reaction from the won't pay owners, because they get, either they get mad, or they're just, now they realize it's not a joke and they know that they owe this debt. So that's, if they haven't contacted us when we sent a demand letter, they usually will contact us when they get this letter. And just going back a little bit, we make sure we send those demand letters via certified mail. So we can get record and have it on record that the owners got the letters. And for the longest time, we've been serving liens by certified mail. Although recently I've decided that I don't think that's the best use of our resources, because a lot of times they'll get returned unclaimed. And I don't, the law doesn't require me to prove that I served the lien, which is different from other kinds of liens that are out there. And so in just sending the lien regular mail, you may get a response from somebody who opens the mail who may not have gone down. If they got a green card in the mail, they might not go down to the post office and sign for something. They don't want to know. But this way they do. And I just had this happen. On a lien I filed on last Friday, and I got a call on Wednesday. Hey, I got this in the mail. Actually, my wife got this in the mail and she was not happy. And how can I get this settled today? And so we worked it out with that owner. But yeah, so it's definitely a part of the process. Is you got to get the message out there that, hey, we've put a lien on your property and you need to address it, because if you don't, we get to step 3. And so step 3, there's a fork in the road here, and I'm going to talk about that a little bit, but I'm going to talk about things. The first sort of biggest and sort of the big hammer that we have as associations is to foreclose the lien. And what do we mean by that is we're foreclosing the lien just like a bank would foreclose a mortgage. The lien is, as I said, it's a second or maybe even a third mortgage on the property if there's a second mortgage out there already, but it's a secured claim, and it's a powerful, powerful tool. Even though it's a very powerful tool, it's generally our last resort, and we don't do this every day, and we don't do a ton of these for several reasons. First of all, they're expensive. It is the most expensive thing from an attorney's perspective in terms of the collections process. Just to get things going is, $1,000 or $1,500 to get one of these lawsuits started. And then there's, more and more and more things that have to happen. Now, we do get to collect that money out of the owner. Eventually they have to pay the attorney's fees, but it's an investment. And so we have to evaluate whether that's a good investment or not. And that's going to depend on some things we'll talk about in a minute, as to, when is a good time to do a foreclosure and when isn't. But another sort of negative about foreclosures is they take a long time. So they're expensive and they take a lot of time. Those are the bad things. Good things are that in a market where housing prices are going up, you're almost guaranteed to collect your money at some point, because as long as there's equity generated in these houses, we're going to collect that money, because people will find a way to resolve an HOA foreclosure, because they're usually not that much money. It may be $3,000, it may be $5,000. I mean, sometimes it's more, but no one's going to lose their home over that kind of money. They're going to go find that money and they're going to get it paid. Now, in the last 20 some years, I want to say 25, but I don't like to admit that I've been doing this for 25 years sometimes, because it's hard to believe, but we've probably filed thousands of liens and hundreds of mortgage or lien foreclosures. And out of those, we've collected a lot of money from a lot of people, but only a handful of those proceeded to the stage where somebody lost their property. And I don't even think a whole handful. I mean, I don't know if it's probably like less than 5 or 6 in that whole time. So it's very rare that the association is going to take something and take this lien and get all the way through to getting a foreclosure and having a sale. Now, it does happen, but as I say, generally people will find a way to resolve an HOA foreclosure because they have some equity in their home. Now, that can change with the economy, and then with all the talk of a recession coming, It may, in high interest rates, it may cause, another issue with the housing market. We don't know how that's going to play out just yet, but we have tools for that when it happens, because low or little or no equity in houses doesn't just result in us not being able to collect our money. It results in bank foreclosures. So during the last downturn and the housing bubble burst, we had a lot of banks foreclosing on owners in the neighborhoods we represent. And so we would get dragged in because they always need association as a potential creditor who has interest in the property as a defendant. The good news is we don't have to do very much, but file a very general answer in court and then see what happens. And if there's any money left, if the property does get sold by the bank, goes all the way through and gets sold by the master in equity, and the bank gets all their money, if there's anything left, then we stand to get what's left. So that's a thing that can happen, and it's something that, as I said, we have to assess whether investing in a foreclosure is a good idea. But it generally, if the amount of the debt, is in the thousands of dollars, and it's been, something that's going on for a while, then yeah, it's probably a good idea to do it. Now we have another way to handle these in the event that the market changes or turns, and we had to do that because when the bubble burst, back in 2007, 8, and 9, we had to find another way because it was not a good idea to take the association's money, file a HOA lien foreclosure, only to have a bank come in and file their mortgage foreclosure, which takes precedence over our lien. Because like I say, our lien is junior in priority to a bank's mortgage, provided that mortgage was recorded before our lien. And that's almost always the case. So that's not a good investment. So what we can do then is we pivot into small claims court. And so small claims court has some pluses and minuses too, and they're a little different. It's generally a lot less money as far as attorney's fees. It's just cheaper to do. It's quicker. We can have those kinds of cases done in 60 days, sometimes even less than that. The magistrate's courts, believe it or not, even though the jurisdictional amount is still only $7,500, most of the debts that we deal with are usually not more than $7,500. So it's an option. And what happens when you bring a case in small claims court is, if you win, which you usually do in these kinds of things, you end up with a money judgment against the debtor, which attaches to all of their real and personal property, not just the house or the condo. It attaches against everything. So that's the positive. The negatives are collecting on this can be super difficult. The first thing you have to do after you get a judgment in any court is send the judgment to a sheriff to collect it. And here's something we all need to know about sheriffs. They want to fight crime. They do not want to collect debts for you. They don't want to do this job, but they're statutorily required to do it. But that doesn't mean they have to like it, and they're bad at this. And I think the person at the sheriff's office who's got the job of collecting these things is probably the person that's got in trouble or is on somebody's bad list. I mean, it's just not, you never see a TV show where the police are promoting the guy from the murder squad into the bad debt collection squad. That's just not a thing. They don't want to do it, and generally they don't do it either well or at all, and it takes forever. So that's a negative. But what happens after that? So the sheriff goes out and is supposed to make an effort to collect the money. That almost never happens. So then they send the judgment back and they stamp it, and the stamp will say nulla bona. And that's literally means no good. But that doesn't end the case. It doesn't end the collections process. It just means then we have an opportunity to make something happen. And what we can do then is initiate supplemental proceedings before the master in equity. And the master in equity is a judge in most every county in South Carolina, the more populated counties all have a master in equity. Some of the smaller counties don't, but the master in equity is a judge whose specific job is to handle foreclosures and things to do with real estate, including HOA liens, bank foreclosures, even construction liens. A lot of times go into there before the master in equity. So what does supplemental proceedings mean is it involves making the debtor appear in court for a hearing to undergo questioning about their assets. And so you don't in America go to jail for owing people money. There's no debtors colonies anymore. There's no sending someone off into prison to await them paying their debts. So you can't get in trouble with the court for not paying your debt. But what you can get in trouble with is for not showing up to court. If you're a debtor and you've been served with supplemental proceedings, you have to show up. And if you don't, you can go to jail for that. Also, you have to answer the questions honestly. And so when you're asked about what assets you have and how you got to the courthouse that day, and what kind of car do you drive, and what do you have, a boat, and do you have jewelry, do you have guns, do you have any other property? So when you ask all those questions of someone in front of a court reporter under oath, and they have either the option to be honest with you or not, but if they're not honest with you and you find out, you can make their lives very difficult. And we've done that in the past, and it's definitely a great power of the court to be able to say, look, no, you're going to take your assets and you're going to pay this debt, and they'll make them do it. So the judge, if you find property, will order that property seized, and then you can sell it and collect your money, or if it could, in some circumstances, just be money. So that they may order a bank to allow you to get that money, but it's part of a process. So in other words, and so just giving you sort of the what's the difference in these two forks in the road. Small claims court is cheaper on the front end and results in a judgment more quickly, but the long end or the back end can be longer because the collecting process of actually getting that money after you get a judgment can take more time, and it's more difficult. I will say that because a judgment becomes a matter of public record, people don't like that. They don't want to have a judgment against them on their public record. So they have an incentive to resolve that debt. And, it's the same thing as having that lien on your property. Only this lien goes against everything you own. And so if you have a judgment that's out there, that's going to make it difficult for you to obtain credit. It's going to make it difficult for you to get a loan, to sell property, to even buy property, or maybe even, in some cases, get a job. So there are implications, even if you haven't collected the money immediately, from having a homeowners association obtain a judgment against someone. But as I said, on the small claims court side, you do spend less at the front end, and you can get that judgment more quickly, but then you have a lot more hoops to jump through on the back end. On the foreclosure of a lien side, they cost more, they take time, but once you get things moving, you're eventually going to get before a master in equity who can sell the property. The big issue there is if there's no equity, then the bank is going to get their money and you may not get yours. So that's something that has to be considered in the process. And so we take that into account in making an analysis and recommendations to our clients as to which way to go. But we're certainly willing to do either way. That is the collections process in a nutshell. And I've been running my mouth for a long time, but lawyers are good at doing that. But I'm happy to answer any questions y'all may have because I know I covered a lot.
Okay, thank you, Paul. So if anyone has any questions, please, if you will just raise your hand, we will turn your mic on, or if you don't wish to verbally say it, we have the Q&A down at the bottom of the screen. When you move your cursor, feel free to type any questions and I can read them for you for Paul to answer. All right, Ms. Marks, go ahead. And you are muted if you'll unmute.
Can you hear me now?
Yes, ma'am.
Did you say that to go to small claims court, the claim can't exceed $7,500?
That is correct.
Okay. Am I still unmuted?
Yes,
You
ma'am,
are.
you're unmuted.
I did have another question. In our case for 69 Morris Street, I don't know if it's appropriate to bring up one single community at this time or not.
Yeah, it's probably not a good idea to discuss ongoing litigation.
Okay, I won't do that then.
But you and I
I'll-
can talk later if you'd like.
Okay. I'll just lower my hand. No.
Thank you, ma'am. Paul, we do have a question about, or asking to cover the total process, starting with what the HOA does before turnover to you as an attorney. I think this is running into the Fair Debt and Collection Act, asking what I believe can be done and how, as possibly a management company, what we can do, what the owner or board can do approaching the owner.
So from my perspective, I look at this in the sense that, obviously there's a statement that's been mailed by the management company that says you've got a debt that's due. At some point, the board may want to take action. In fact, I've had board members of different boards who say, I want to go down and knock on so-and-so's door and ask them about this. And we don't recommend you do that. And the reason is because of the Fair Debt Collection Practices Act. You don't want to be seen as harassing someone for the money. The other thing is you don't want to ever broadcast the business of what a particular debtor may owe you as an association to the public, because there's a lot of the things that could go wrong. It's like the old adage about passing the football in a football game. It's like three things can happen when you pass a football, and two of them are bad. So, you either fumble, or the pass is incomplete, it's intercepted, or you complete the pass, but the first two are bad. So if you're talking about people's debts or putting that out there on the street, or engaging in some sort of, behavior that you're trying to coerce someone into paying, the ramifications to the association and potentially board members who do things like that, you can get sued for that. And you don't want to be defending Fair Debt Collections and Practices Act case. Those are filed in federal court, which means that's expensive and you're probably going to need a lawyer, and it's not a good situation, and you're just opening yourself up to it. So what I want to talk about in that regard is you've got the ability to send this collections matter to us. And once it is sent to us, we are not beating up on these people. We're not mean to them. We treat them with respect and professionally. And I had a lady send me a check for, believe it or not, $17,000, and told me that I was the nicest guy that they ever dealt with. They never met a lawyer they like more than me. So I don't know. And keep in mind what the goal is. The goal is to collect the assessment. The goal isn't to take somebody's house or to make them feel bad or be mean. And so we are very careful in how we approach communications with owners. We are, compassionate and caring. We're firm. We say this is something that's got to get resolved, and here's what's going to happen if it doesn't. But there's no point in being mean about it. It's just not part of the process, and it's not part of our process. So again, though, I think getting back to the original question and the point that's out there, which is, it's not a good idea to put that information out into the public. Like, for example, I've had boards who want to, publish a list of the debtors on their website. And I'm like, that is a terrible idea, because what happens when somebody mailed in a payment, or brought it by the management company's office 2 hours before you posted that on your website, and that makes it not true. And so now you're going to get sued. And it's just the benefit of doing that does not outweigh the negative side of it. Okay, and I saw Mr. Malone. Thank you for being here. I've known him for a long time. He's asking about, is there a difference in collecting assessments versus violation fees? And I would say it this way. It's not that different, but it's not the same. And what I mean by that is, as we were talking about earlier, and if you're in a horizontal property regime, you don't have discretion to not collect assessments. You're actually obligated to do it. That's one of the jobs that the Council of Co-Owners, which is what they say in the act, but what it really means is the board. The board of the association, it's their job to collect those assessments. It's not their job to issue violation fees necessarily, or to collect those, but they can. It's within the powers of the association. But as I was saying earlier, the big difference is their discretion. And in a condo regime, there's no discretion for an association to take less money, because by statute, you can't reduce the obligation of one person, because that would make other people have to pay more. And it's just, the statute says what it says. I think the difference there is, if you are a condo association and you have violation fees you've imposed, there are two things I want to talk about with that. One is the violation fees, I think, are fine. I don't have a problem going to collect them, but they're harder to collect because you got to prove them, right? So that means you're going to have pictures, and you're going to have a witness testify about what it is, that violation, when it happened, how it happened, why it's a violation. All those things are not necessarily achievable in the same easy way that putting a verified statement of account, saying, here's the account of the association, these are the assessments, this is what's not been paid, and sending that to the court. I mean, that's a totally different standard of proof and a level of process that you have to go through. That's one reason that I think they're harder on that side. And then the other thing is, but going back to it, the good news, I think, is that's something you can negotiate. So whereas you can't negotiate the assessments, you can negotiate on those fines. And so, if it gets out of hand and you've got somebody who's just not complying, and you want to bring those fines to make them comply, eventually those are going to add up. And I've seen it in some cases I've worked on over the years where they've added up to tens of thousands of dollars. And the owner got bad advice and just didn't stop doing what he was doing, and eventually it did not go well for them. So yes, you can enforce those things. I think the nuance is a little different. I also think you've got to understand that when you go to court asking a court to enforce a violation fee, you're going to have to get a buy-in from the court on what that is. The judge or the jury is going to have to buy into what you think. You may have a rule that's on the books that says, we don't want people, mowing their lawn on Sundays. I don't know that, whatever it is. But if the judge thinks that's a silly rule, he's not gonna give you the benefit of the doubt. I was just telling you from experience, they're just going to not enforce it because there's not enough money involved for you to appeal it. So we've always got to think about, what is the saying? Is the juice worth the squeeze? I guess is what they say. But you've got to say, okay, am I being reasonable? And if I am being reasonable and this owner is just abhorrent, then yeah, let's go for it. And we've dealt with really bad owners. I mean, I know Helen remembers the case of the guy who built an above ground pool in a multi-million-dollar neighborhood. We had this, gosh, almost 15, 18 years ago, we had that case. But yeah, I mean, it was, no amount of convincing this guy. He said, I'm going to do what I want to do. And well, ultimately, that's not what happened. So that above ground pool is not, I don't think it's around anymore. And I don't think he owns that house anymore either, but that's a story for another day. What
So,
are the questions
Paul,
can I answer for you? Yes, ma'am.
Question on these violation fines, when you're talking going to court, you're talking about taking someone to small claims court to collect? And second part is, would you file a lien for violation fines alone?
I wouldn't recommend that unless there was something going on. I mean, like a trash can or power washing thing. No, if someone's like, doing something really bad, then yeah. But there's a lot of skepticism from the courts about these kind of things. And there's been a lot of bad publicity about, associations overreaching. So I think you've got to really, you just have to use judgment. And, given that I know Helen's been working with me on this just as long as I've been working on it. So, if you ask us, we'll tell you what we've experienced, and we've experienced a lot of things. So, I think but what it comes down to is just, using judgment. I mean, I don't think, let me put it this way. If you have both assessments and violation fees, why not file a lien, right?
Yeah.
But if it's just violation fees, I don't like that because I don't know who's going to be around when it comes time to try to collect that. And like, just as Helen said, if it's violations, a lot of times those end up in small claims court, and that's probably a good thing. But not always, because we tried a case during COVID with a judge who's now retired, thank goodness. But I mean, he did not follow the law. He did not follow the documents. He just decided what he thought was the right thing. And, the amount of time and energy that went into like getting ready for that trial and trying it. And we ended up trying it for like, I don't know, 5 or 6 hours over something that should have taken 10 minutes. And so thinking about all the money they got invested and all the time and aggravation, you've got to know that you're going to come up against people in the judges who are going to, turn a pretty strict eye towards what you're trying to accomplish. And they're going to, hold you to account as the association not to overreach, because there is honestly, there is a presumption in the law that, people should be able to use their property as they want. That's why they call them restrictive covenants, because you're restricting what people otherwise would be able to do. So those are looked at, with strict scrutiny, as opposed to, oh, he didn't pay his dues. Okay, that's easy. The judge is going to say, where do I sign? Where do I sign the order? That's a no-brainer. So I hope that answers that question.
It does. Mr. Donovan, you have a question?
Yes, hey, thanks, Helen, for putting this on. One of the things that we are early in our evolution of an association. Is there a standard list, and Helen, it's maybe you and Paul working together, that we could put, this is the process that we're going to follow first?
Oh, I think that's a great idea, Mr. Donovan. Having a board come through with a collections policy, and we can provide one to your association. We have sort of a model one that we use, but yeah, we can provide, here's the thresholds for when letters get sent. We
Yeah.
don't just send letters when somebody owes like $100, you know. We have like, you know, maybe it's $500. Depends on the association and how often the dues come, you know, if it's monthly or yearly. But yeah, we can definitely work with you. It's not, we already have sort of a template, and we can, you know, work it any way you want. There's a couple good things that come with that though. So if you have a board of an association has a collections policy in place, number one, you can tell the unit owners that what that policy is. You can publish that to your website, or, you know, just have it out there. And hey, this is what we're going to do. So then they know. And the other thing is, if you have that policy and you stick to that policy, that eliminates claims about people being discriminated against for a variety of reasons. And I'm not just talking about race or anything else. I mean, it could be you're discriminating against me because I don't live on the water side of the street, you know, or my house isn't as nice as yours, or what. It could be anything. But if you're treating everybody under a policy that's already in place and it's expressed, and you're actually following that policy, that's you know, that removes an argument from debtors trying to, you know, throw mud into your eyes when you're trying to collect this money. So yeah, I think that's a great idea.
So Helen, that's something would be big on our plate.
Yes, sir.
That'd
I'll
be
follow
great.
through with Paul on that. All right.
The other
Any-
thing, Paul, I had was, we have taken over from, you know, obviously the builder was the original HOA board. And there was confusion over payments and discounts and all the like. And we had, not to talk specifically, but we had one that's in a little bit of a debate with the builder. And almost refused to pay us. Helen got them to pay. But is there something we could put up and saying the HOA is the HOA and it's not the builder? Or is that something?
So yeah, I think that I'm familiar with what you're talking. I know the case you're talking about, but I'm, you know, not, this isn't really the place to discuss that. But what I will say is, yeah, I think, you know, we have to look at how your turnover went. I understand there might be issues with the builder, and we can talk about those too, and how the turnover of the association was handled and that sort of thing.
Is an
but-
understatement.
Yeah.
So I think that's what it's probably, and I'm not trying to be specific, but on a general side, you know, people were quoted that they paid half or this commitment.
Right.
Pay all of it.
So the way I look at that is that's between them and the builder.
Right.
That's not the association's problem. So,
And I think Helen, maybe we take that offline is the couple we have on that. I would love to get a letter out to them to that specific nature.
okay.
Got it. All right.
Thanks,
Thank
Helen.
you. Certainly. Any other questions? Comments? Well, Paul, thank you very much today. You've given a lot of information, and I have a feeling we're going to get a lot of questions after the fact that maybe we'll do a e-bulletin or an email to those that have joined us.
Sure.
We have recorded our session today. It will be posted so that those that were not able to join us will be able to. And thank you, everyone, for your time and for coming with us today. Have a good weekend, everyone.
Thank you all.